Okay. Two more ones.
May it please, my lord. If I may take my lord's indulgence, my lord, I beg to mention item number 1 of the part 2 list, my lord. I am seeking accommodation only for today, my lord. I have informed the council for the petitioner, my lord.
Just a moment.
My lord.
Part the list. You have for respondent number 2.
Number 2, my lord, yes.
Number 2 is that what you call
My lord, the company, my lord.
the company.
Yes, ma'am. Only for today, my lord.
Okay. Okay, it now be called.
Obliged.
Yes.
I pray for listing of this matter for admission, my lord. Say tender matter, there is a stay operating. Can it give another episode of the case?
Give to the court, prayer for listing, give it to the court master. He will have to make some adjustments.
Obliged.
All prayers for listing, please give it to the court master.
Similar prayer.
Give it to the court master.
Thank you, Your Lordship. Your Lordship, I beg to mention for withdrawal of writ petition number 8449 of 2022. Your Lordship may kindly allow us to withdraw, Your Lordship.
Okay, give it.
Your Lordship, there is another case also. Writ petition number 802 of 2023. It also may be withdrawn. Much of.
Yes, Mr. Pathak, your matter. How's your health now?
Some checkup.
Checkup we can do, we can shout and make your heart assess your. So far as checkup is concerned, we can shout and check your heart.
My lord, that has become the norms of the day today inside most of the courtrooms. But to which school I do not belong to.
No, but still it checks all those heart problems and other problems with the head and heart.
The head problem is welcome, but heart problem is not welcome.
No, it will give a check.
Yes, yes.
It will give a check.
Yes. Arguments should not be confused with shouting.
Well, it emanated from the place from where you have come. That has led the light.
Basically, no amount of shouting can help a logic to arrive at.
So that is okay, but this practice emanated from
My
where you
lord,
have come.
my lord, my lord. I bow down my head to my senior.
I have an experience, I won't say the name, it's a very respectable name. Then I was in practice, the learned council came, shouted at the top of the voice in a company law board,
I understand now.
and shouted at the top of the voice 45 minutes non-stop submission, and he left. And the honorable judge, I forgot the name, I think Deshpande, from he just look at the council going out. After 2 or 3 minutes, he asked the instructing council, "Kya bola?"
And by that time, most of the council was out of Assam. The senior council has left Assam by that time.
No, it was in Delhi.
I see. But sometimes it happened also here.
So then I realized what you have said is absolutely right. Yes.
Well, in item number 1, the return candidate being aggrieved by the order passed by this court in order 7 application filed in SLP. So that SLP order has been brought on record by IA number 1671. iPhone also. The order is at page 13 and 14.
Okay.
Madam.
Okay. Heard Mr. K.P. Patel and senior counsel, assisted by Mr. A. Barwal and counsel for the petitioner. as well as Mr.
NJ Chaudhary on behalf of Mr. Pia.
Anjit Chaudhary, the counsel for respondent number one.
Petitioner in the election petition.
So here you are opposite party number one.
Yes.
Opposite party number, applicant, opposite party number one. First of all, by filing this interlocutory application, comma, the order dated 26/4/2023 passed by the Supreme Court of India in petition for special leave within bracket C number 9885 of 2023 is comma, by which the proceedings is stayed has been brought on record. First of all, accordingly, this matter is adjourned and adjourned sine die. Based on the outcome of the proceedings of the said SLP, comma, the learned counsel for the petitioners would apprise the court. Sorry, the counsel for the petitioners would apprise the court of the outcome of the
My lord, it should be intimate the court, my lord. We are not supposed to advise the court. Will intimate.
intimate, okay, intimate the court about the outcome of. No, I said apprise.
Oh, apprise.
No, it's okay.
I heard is that.
No, it's okay,
Okay.
but your word is good, better. The outcome of SLP civil 9885 of 2023.
All right.
Mr. John Sinadai. Oh, even in election, yes, in the election petition also, in view order passed as well, so. It's in joint secretary. Okay, now. He will become the petitioner and he will be respondent number one.
Password for the timing.
Time being,
Yes.
okay,
Hi,
number 5,
item number 5.
In this writ petition, a government policy has been challenged, Your Lordship. What actually happened? In a series of cases decided by a coordinate bench which were tagged, this matter was not tagged together. The series of cases has been disposed of and writ appeal is pending against those cases. Your Lordship, the facts,
duty ration cards.
yes, sir.
I think that was dismissed.
Yes, sir. And writ appeal is pending against all those. If Your Lordship pleases, I may convince Your Lordship, if Your Lordship pleases can direct this writ petition to be listed with the writ appeals, Your Lordship, because the fate will be the same.
I can direct the division bench to take up a matter. You can pray before the division bench to take up this matter.
Yes.
But I can't
And
probably tell the larger bench what to do.
I understand.
I'll just say on the prayer made by Mr. B.J. Mukherjee and counsel for the petitioner, the matter stands adjourned today. Ms. S. Sharma, then the government advocate is present.
Six.
Yes,
Lordship, my senior is on legs in another courtroom. Kindly pass over the matter for timing.
the next para. It is noted that In the order dated 11/1/2013, passed in WPC 2194 of 2012, this court had taken note of the fact that the land in question was under occupation of Regional Dental College with a construction of two-storied RCC building in the middle of the land. Full stop. Therefore, comma, it cannot be accepted that when notification dated 8/3/2013 was issued, comma, the land in question was a waste or arable land. Full stop. Moreover, in the affidavit in opposition, filed by the respondent numbers 5 and 6, comma, it is not the stand of the additional deputy commissioner that the time of issuing land acquisition notification dated 8/3/2013, comma, the Regional Dental College did not exist. It was not standing on the land, and the land was an arable or a wasteland. Full stop. That's correct. Accordingly, comma, the indelible impression of the court is that neither the land of the petitioners that was acquired was an arable or a wasteland, and more so the conditions envisaged under section 17 within bracket 2 of the Land Acquisition Act also did not exist on on the date when the notification dated 8/3/2000. 8/3/2013 was issued. 13. 8/13. So the state respondents have not been able to demonstrate that in connection with the acquisition of the land in question of the petitioners, the provisions of subsection 1 or subsection 2 of section 17 was applicable. Full stop. As already indicated above, it may be mentioned that there is nothing on record to show that a notice envisaged under section 9 of the Land Acquisition Act was issued. Which is a precondition for exercise of power under section 17 within bracket 1 of the Land Acquisition Act. Full stop. Therefore, as subsection 1, as the provisions of subsection 1 and subsection 2, or subsection 1 or subsection 2 cannot be applied in the present case in hand, the Deputy Secretary to the Government of Assam, Revenue within bracket LR bracket close department, could not have invoked the power vested under section the subsection 4 of section 17 of the Land Acquisition Act to direct that the provisions of section 5 capital A would of the Land Acquisition Act would not apply. Therefore, in view of the discussions above, the court is of the considered opinion that the land acquisition notification as published in the newspaper on notification dated 8/3/2013 in LA case number 11 of 2001, as published in the newspaper on 16/3/2013, is vitiated on account of acquisition being made in excess of power under section 17 within bracket 4, exempting the requirement of section 5 capital A of the Land Acquisition Act. Full stop. Next paragraph. At this stage, the learned standing counsel for the Revenue Department has submitted that as a public institution has already been set up by way of a regional dental college on the acquired land, if a constitutional order of reversion of the land to the petitioner is ordered, it may cause irreparable public what is called public it will be contrary to the public interest. And it submits that notwithstanding that this court has found fault in the issuance of land acquisition notification dated 8/8/2013, a reasonable opportunity be given to the, a reasonable time be given to the competent authorities to issue a fresh land acquisition proceedings. He further submits that even if the state government proceeds to acquire land under the Assam land within acquisition and requisition, or it is requisition and acquisition, which is there? Yeah, Requisition and Acquisition Act, 1964, but the procedure for assessment would be same as prescribed under the right to, what is that? Right to fair. Put on your speaker, please.
It will be right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013.
13. And accordingly, it is submitted that notwithstanding whatever act is applied for acquisition, the petitioner would not be deprived of a reasonable compensation. It's the word is reasonable.
Reasonable.
Yes.
What in the act is reasonable, I think, or a fair compensation. Okay,
Fair
reasonable and fair compensation.
Fair compensation.
Okay. The said submissions is considered and found acceptable in view of the fact that this court by judgment and by this court by order dated
My lord will find my lord at that.
30/11/2010,
Yes, my lord.
passed in WPC 834 of 2005, had also taken the same consideration. Next paragraph. It would be relevant to mention that in the following cases cited by the learned senior counsel for the petitioner, the Supreme Court of India had held in a catena of decisions, including the ones cited by the learned senior counsel for the petitioner, that invoking of urgency provisions under Section 17 to eliminate inquiry under Section 5(a) of the Land Acquisition Act should be invoked only in deserving cases of real urgency and should not be adopted as a matter of practice. In the case of Anand Singh within bracket Supra, while restating the object of Section 5(a) of the Land Acquisition Act, the right of the owner to file objections to propose acquisition was restated to be not only an important and valuable right, but also makes the provision for compulsory acquisition just and in conformity with the fundamental principles of natural justice. Full stop. A three-judge bench of the Supreme Court of India, while deciding the case of A. Ishwar Lal, ISHWARLAL, Girdhari Lal, Joshi, within brackets Supra, after referring to various, after discussing various case laws, including case laws as well as definition of the word inverted comma arable, ARABLE, in the Land Acquisition Act. That arable land is meant not only land capable of cultivation, but also actually cultivated. My further observing is that it is not arable, not because it is cultivated, but because it is something else, such as waste, pasture, ancient, ANCIENT, ancient meadow, MEADOW, etc. In the present case in hand, admittedly, when a building of the regional dental college is standing on the land, it cannot be said that the land is capable of being cultivated. In the present case in hand, the land was in occupation of the authorities under the Guwahati Medical College and Hospital since 1981, and therefore there was no real and substantive urgency warranting invocation of urgency clause and to dispense with the inquiry under Section 5 capital A of the Land Acquisition Act. Mr. Saiwala, any more citation you want us to include, or that will be enough?
I think I have a lot of 2015-10, my lord, the last portion that your lordship wanted to say, that can be here. Here, they have
2000?
said, they were
15-10.
allowed to initiate test verification.
2015-10.
Yes. Surajmal Nagaraman. That is also was Section 17 case, my lord, Section 17.
The last, para 12, last sentence. Is it not there? I think.
No, it's not there.
Oh, I'm sorry, madam, I'm. There are some other aspects are there. Non-compliance 11A. 17. Last sentence, para 12.
Uh, Next para. Taking note of the fact that the land in question is in possession of the authorities under the Guwahati Medical College and Hospital, and a regional dental college is being operated there from, comma, by following the judgment of the Supreme Court of India in the case of Surajmul, SOORAJMULL, Nagarmul, NAGARMULL versus State of Bihar and others, comma, 2015 within bracket 10, SCC 270, comma, the court is inclined to, while setting aside the impugned land acquisition notification number so and so dated 8/2013, as well as the case of Avinash Sharma within bracket Supra, as the land is vested in position, is vested in the, is under continuous position of the state government, comma, court is inclined to hold that the present requisition proceedings with regard to the subject, with regard to the land in question of the petitioners must be deemed to have lapsed. However, the state government, the appropriate authority in the state government is at liberty to initiate fresh acquisition proceedings or to take any other action that may be available to it under in accordance with law within an outer period of 4 months from today, within bracket 4 months from today, during which the during which, as the land acquisition proceedings has already been set aside and declared to have lapsed, comma, the land would become entitled to be restored in the name of the petitioner in the record, petitioners in the record of rights Next, madam. The representation has allowed in terms of discussions above. Next, the petitioners shall produce a certified copy of this order before.
One another aspect, my lord. Because if they fix the compensation again, my lord, after acquiring,
Oh,
then they
sir.
can adjust it.
Well,
Okay,
that adjustment part, yes,
Because division bench judgment, my lord, I have
Uh-huh.
placed before your lordship, my lord.
Make that submission.
Read appeal 2019-17. The last page, my lord, your lordship, can see,
Next, madam.
if they fix it.
Insofar as the,
Otherwise,
insofar as the continued possession in respect to the land is concerned, which is being enjoyed by the state through its through the Guwahati Medical College and Hospital, till such time fresh notification is issued, the petitioner would be entitled to rent,
Right, yes,
Rental.
definitely.
to rent, huh?
Rental compensation.
Rental compensation. Full stop. Moreover, as pointed out by the learned standing counsel for the revenue department, that under protest, part of the compensation amount of rupees,
My lord, that's- I think, check it out. My lord, yes, I'm.
Well, the one is,
there's okay, I've given already given.
Already
So-
said.
already stated above, compensation of so and so already paid to the
yes,
petitioner
that will suffice.
is liable to be adjusted against rent and or future land acquisition compensation as may be determined. And in this regard, the court places reliance on the judgment on order dated 14/3/2019 passed by the division bench of this court in W 8219 of 2017.
Well,
Repression stands up to the extent is discussed above, then now it will come this, that parties are left to bear their own cost.
But only two humble prayers, my lord.
Yes, yes.
Yes, my lord, the certified copies, my lord, which lordship has directed, my lord, let it be, my lord, furnished to respondent number 2 and 5 simultaneously. My lord, this will
Okay.
ease up, my lord, speed up the process.
Certificate copies will be served by the petitioner on the respondents.
My lord, 2 will be the deputy secretary to the government of Assam Revenue Department, and respondent 5 is the deputy commissioner,
2 and 5.
2 and 5.
Well,
One
My
second.
lord,
we shall-
Second humble prayer, my lord, with all respect, my lord, that outer limit, my lord, of 4 months, but can it be from the date of receipt of certified copy of the order?
Yeah,
My lord,
4
I will
months.
communicate immediately, I will communicate.
4
once it
months
is
from the
uploaded.
date of service of certificate copy of the order on the respondent numbers 3 and 5.
2 and
2 and 5. Okay, 2 and 5. Okay.
I'm so obliged, my lord.
He has saved. He should come into the profession of business. He is very prompt in what you call calculations. 4 or 5 days, he has taken more advantage. No, I don't regret it. I don't what you call. I'm just appreciating the what you call the presence of mind you have in the courtroom. I'm appreciating it. It's not a
My lord,
statement in derogation.
I take
It's a
it, my
statement in appreciation.
lord. Defending the state in this kind of matters is a happiness, thus, my lord. Difficult, my lord. Get you. Or
Sorry, my lord, in the first step, I was not present. Because on the last occasion, lordship heard the matter, my lord. This is with regard to inclusion of some of the villages while constituting the demo town committee, my lord.
Yes, demo town committee, yes.
So we have filed, the deputy commissioner filed one affidavit in the case, lordship. Basically, After it was being published. Lordship may see para number 7 of the affidavit in opposition.
Para 7.
Para 7 Lordship of the affidavit in opposition. May I just read your Lordship.
Yes.
That in view of the facts stated herein about the urban development department government as by way of gazette notification so and so informed the general public regarding the intention of the government to constitute a town committee at Demo, and the area proposed to be included in the town committee was also published, and objection, if any, were called for from the local public within 6 weeks through the deputy.
No, but
commissioner.
Mr. Barua, you
Okay.
see, the fact is, let us say a hypothetical situation. This order in the writ petition which I will be passing, I propose to send a press release to the newspapers. Correct? Now, in the end of the order, I say that the registry shall issue a press release to the newspapers
Yes.
of this order. Now, are the newspapers bound to publish it just because I have sent? Or DIPR sends it? Is there any agreement between you and between the DIPR and the newspapers that all press release issued by the DPR will be published? So therefore, presumption of a publication cannot be made unless you show that it has been published.
Second thing is Lordship, damages Lordship. Why are we proposing to constitute that, converting that area to a committee, to a this thing, committee Lordship? Because so that public can enjoy various central government schemes Lordship.
It is okay. Then why you see why people are being why in the in this every part of the country there are what you call police action taken against persons who are wanting separate state. Somebody is wanting a separate country. So there is a demand committee for everything. I need a what you call state of Pandajar, because it would be convenient for me or anybody else who is wanting that demand to become a chief minister of the state of Pandajar. Correct. Somebody will say that no, I want a state of Uzambajar.
Yes.
Now there is a demand committee for everyone, everything. Now does the government go on accepting the what you call demo what you call town committee, demand committee, and you start a committee just because somebody has demanded? Because you must show some rationale that why other demands, why this demand was accepted and acted upon within a short time. A citizen has a right to object if you don't publish it, if you don't show it.
Now, basically, Lordship, where still the stand is set, whether you have so given any objection to the concerned authority.
No, unless you publish, how will I give it?
Lordship, okay, Lordship, it is not, okay, Lordship, we presume that it is not in the newspaper. But otherwise, it is already there, Lordship, as per our distinct copies of the aforesaid government notification and the press slip. So.
No,
Lordship,
Mr.
it is, Annexure 7 and 8, Lordship.
No, Mr. Mr. was showing us this, sorry, Mr. Gupta was showing us something which says that it has to be published in the newspaper.
But it is said, it is decided by the government that how it is to be, section 334 of the Assam Municipal Act.
What does it say? Guy, we give wide publicity.
Alright, a copy of the notification under subsection 1 shall be published in such places as the state government may be general or a special order direct. But in this case, my lord, only gazette notification is there, and in the affidavit they says that they have given one press release.
Speak to Mr. Sharma.
A copy of the notification under subsection 1 shall be published in such places as the state government may be general or special order directors. So
And you know the interesting part, what is happening? You come to running page 77, annexure 8, which you are reading. At David page 22. Running page is 77, internal page is 22. Of the Deputy Commissioner's affidavit.
affidavit, Lordship.
Deputy Commissioner's affidavit,
Yes, Lordship. Para number.
page 22, running page 77, annexure 8.
Yes, Lordship. This government decides to, yes.
Press release. Huh.
Yes.
Interestingly, the Deputy Commissioner's office has given a receipt seal down below in the middle. It is not an issue seal. Central receipt number.
Yes, this is after giving to the newspaper authorities. There's
No,
no.
ADC within bracket, what is, it should be over D. Please put up. 12.6,
12.6.
correct. 13.6, there is a round seal in the top,
Yes, Lordship.
correct. Which your own department has, your Deputy Commissioner office has received it on 16.6.
Yes, Lordship.
Then again down below there is a note, number 4036 dated 21/6/2012.
Yes, Lordship.
So when was it actually issued? It's not there. So you see, you prepare this press release, number 348, down below left side is a date 21/4/2012.
Lordship.
So it is prepared on 21/4/2012 until 21/6 it is, this is leisurely roaming in your own Deputy Commissioner's office.
And Lordship, in the Assam Gazette, Lordship, it was been published in 29 previous by Annexure 7, Lordship.
29 February 2012.
Lordship, by Urban Development Department. And if I'm not wrong, Lordship, that decision has been communicated to the DC, Lordship, by Annexure 8, Lordship.
No, whatever you say, I'm not contesting it. But you
But
see,
the only thing, Lordship, I understand this is a whether question of communication, Lordship. Whether that
the
Sorry.
communication is a proof of actual information to the public.
Lordship. So, Lordship, basically 334 subsection 2 shall be published in such places by the state government, may be general or special or direct. That part only, Lordship.
No, you see, there are two parts. Number one, you come to this section 334(2). 334(2) says
Yes, Lordship,
a
that
copy of the notification under subsection 1.
shall be published.
Therefore, merely a gazette notification will not do. A copy of this gazette notification shall be published in such places as state government may require. That means this gazette, apart from being published in the official gazette, must also be published in specified places.
Lordship, may I just pray, Lordship, one thing? Can I get specific instructions on this point, Lordship? At the
You
earliest,
definitely
Lordship?
have it. Because if you want to save this town committee,
Lordship,
you'll have to produce it, because otherwise we'll have to accept
Lordship, Lordship,
what Mr. Gupta is arguing. He has made out a strong case.
Lordship.
He's waiting since 2013. 2 days more will have no effect because he's enjoying a stay order. Say A.K. Gupta, counsel for the petitioner, is present. In view of the provisions of subsection 2 of section 334 of the Assam Municipal Act, 1956, and on the and having regard to the plea taken by the Learned Counsel for the petitioner, that press release number 348 within bracket annexure 8 to the affidavit in opposition filed by the Deputy Commissioner Sibsagar on behalf of respondent numbers 3 and 4, which do not indicate the manner of publication. Or manner in which wide publicity was given to the gazette notification dated 7/1/2012, the Learned Mr. C.K.S. Barwar, government advocate, praise for is granted 2 weeks' time to obtain instructions. Next, it is made that this writ petition is of the year is filed on
2013.
Huh?
1/4/2013.
It's fine. 1/4/2013. No further adjournment will be given in the matter. Next, the matter is in the part 2 list. The same will be called. We are giving 2 weeks' time, 14. Today is 15. We've taken up on 28/6/2023. Will be called again on so. But give him time till 28th. Instead of 2 weeks, make it 28th. This list is valid till 28th. Sorry, 30.
So I'll,
Okay.
before 30 also I can produce it.
Huh?
Before 30 I shall be able to.
Um, Interim order,
That is until further.
it's until further orders, okay.
No solutions.
Seven.
Mr. Barwa, in the matter of Mr. Prakash is sitting behind, I was requiring either you or the senior advocate, senior government advocate. You see, here two girls are missing. Inquiries are made, the Superintendent of Police has made a disclosure in their affidavits, but it's a 2000 item 4 Mr. Item forecaster item 2.
It is of
Yeah, two.
2012.
Give it to him. Item 2, file 2. You see, in this case, the FIR was lodged long back. Huh? The recorder, order sheet, yes, sir. Huh? Now, on the last occasion, we passed an order. Look at this order.
On 6/6, I think. Madam.
Because then I'll direct the appropriate, what you call, investigating agency to take up the investigation.
Yes.
If for 11 years the Assam police can't investigate and close the matter, the girls were going to school, they were kidnapped and taken away. And if the investigation is not completed, we'll ask this will direct the investigating agency to take up, and we'll monitor the investigation then.
Not.
Nobody is responding to it.
I've been provided with one record, Lordship, and it's supposed in connection with police. So have to examine it, Lordship.
Yes, send it, pass it on, let me see.
Yes, sir. Yes, that is.
No, this what had happened was last time the case diary was here. And since the case diary was here, conveniently the what you call, there is no prosecution investigation. Therefore, I directed on the last occasion, who was there, I don't know.
Check, yeah.
I directed that the photocopy of the case diary be retained and the original case diary be sent back.
So Lordship, I've already seen that.
Now,
And Chetia, Mr. And Chetia.
who were we? I don't remember the names. But you see, what has happened here,
So is this a prayer of the petitioner that to transfer the case to some CID or CBI like that?
he only wants that the girls' whereabouts be known. He's
Right.
not asking that give it to him or her.
Perhaps if he is not satisfied with the investigation, because. it
No,
is
no,
not-
we are not jumping into conclusion. Mr. Purgasta has not said that he is not
Yes, sir.
satisfied with the investigation. But what would happen if girls go missing and then investigation is not even concluded? What happens? How many years somebody can wait?
So let me do one thing also. Let me write a letter to the concerned authority.
You don't write a letter. You send a crash message through our VHF. Writing letters will take years and years and years to reach him.
Special listing. Messenger.
No, don't send it by messenger. We have installed a VHF for you. Use that. If you send a message now, it should reach the authorities now.
This is the updated status of the.
You see, yesterday's Assam Tribune, read that first page of Assam Tribune. There's a reason to say so. In the first page of Assam Tribune, there's a half-page advertisement published at the Public Exchequer's cost, stating that police services can be availed over phone, WhatsApp.
Yes.
Electronic media, so all this.
I don't know, that much I don't read. I read only that much by which I can start a gossip.
And nowadays, also, in fact, it is not compulsory that we have to, you can just call them up or whatever. you
No,
can
no,
just-
but you see, I'm anxious because of the fact that
I understand, Lordship, the gravity of,
two girls go missing.
yes, Lordship, you can,
The guardians are running in court since 2012. Today is 11 years of this
I
repetition.
understand the gravity. Lordship.
The anxiety is how much more Mr. Prakash will run.
Yes, Lordship,
May I just suggest, my lord, if you otherwise it is.
it is
acceptable
not
to
an
my
ordinary civil matter, Lordship.
lord. Let court, my lord, issue a positive direction to the highest authority of the district to inquire and submit a report.
So that we have done, but they have not responded. Last order, that is what we have asked.
Lordship will have the other measure, my lord. If they don't respond, their affidavit is absolutely not clear.
Yes, this order is also here with you. Mr. Sharma. Barwa,
Lordship.
this order 66 is with you. That means the
We have
government
communi-
advocate
we have
has
com- we have
communicated.
we have communi-
Just pass me that communication.
Email, Lordship. And I have committed to SP of Kasar.
Mr. A.K. Prakash sir and counsel for the petitioner. As well as Mr. C.K.S. Barwar and government advocate appearing for the respondents. Next paragraph. This court by order dated 6/6/2023 expressed its anguish to learn that the investigation of Lakhipur PS case number 190 of 2012 has not yet been brought to its logical conclusion. And therefore, this court had directed the Superintendent of Police, Kachar, to examine the case diary to find out the reason why the investigation of the case could not be completed. Full stop. It appears that, as this court had not made an observation that he would inform the court, that the Superintendent of Police, Kachar, would inform this court about the progress of investigation, perhaps the said authority did not deem it appropriate to revert back to this court. Next, accordingly, as the order dated 6/6/2023 is found to have been communicated by the Office of the Senior Government Advocate of Guwahati High Court, the Senior Government Advocate Assam, Guwahati High Court, by email dated 12/6/2023. The court is inclined to issue a direction upon the Superintendent of Police, Silchar, Kachar, Silchar, to inform the court about the progress of investigation in form of a report. Full stop. Next para. The state government
Manipur is illegal.
is through the Home Department is looked after by whom? Principal Secretary or Chief Secretary? Sorry, Additional Chief Secretary.
Additional Secretary.
Additional Secretary.
Additional Chief Secretary.
Additional Chief Secretary. Okay. The Additional Chief Secretary, Department of Home, and or any other head of the department by whatever nomenclature, to notice as to why the investigation of this case should not be handed over
Lordship.
to the
CBI.
Central Bureau of Investigation on failure of the state police to bring a closure to the investigation of Lakhipur PS case number 190 of 2012, even after 11 years. Full stop. Next paragraph. The learned government advocate is requested to transmit the order of this court to number one, the Additional Chief Secretary to the Government of Assam, Home Department of Home, number two, the Director General of Police, Assam, number three, to the Superintendent of Police, Kachar, Silchar. Full stop. The court expects the said authorities to have interstate communication amongst each other and submit and so that a conscious report is sent by the, so that an appropriate report is sent by the Superintendent of Police, Kachar, Silchar to this court, so as to positively reach on 28/6/2023. Full stop. This matter will be taken up in the next call. And as this matter is in the part 2 list, this matter would be again called on 28/6/2023.
In the Delhi. So I thought in the Delhi was listed.
No, it will not come. I will just take up in the next call.
That will be more appropriate because one part of the cause of action lies in the state of Manipur also. Therefore, CBI will
So
be
whatever way,
the-
so I have made a mention so that all these three authorities, they at least deliberate and send us a report.
Lordship.
Otherwise, the SP will say that we have written to DGP, DGP will say we have written to Home will say that, well, I have no communication with the
No, here in the
Superintendent of
affidavit,
Police.
we have issued to OC Panamba of East Imphal, Manipur. So that is going on, Lordship, because if it doesn't involve CBI, one state will be dependent on another state, Lordship. So
No, you can't take that plea for two reasons. Number one, that you have not brought on record anything that the state of Manipur has refused to cooperate with you.
no, that is
Correct. Number two, precursor to what I've said first, is that you have taken an appropriate steps for the purpose of investigation, because you see, you have to show us that you had a police team sent there for the purpose of investigation. They would have given some report, and then it would have been forwarded in the form of entries in the case diary. Because you see, if a police personnel goes there
Lordship.
and comes back, he'll give a report that I went
I
to
will-
so and so police station, contacted the officer in charge of so and so or the circle inspector, but they refused to give us the appropriate assistance, and therefore they will write to the Superintendent of Police for further action. That is the normal procedure. Because then it will go to the, what you call, Director General of Police. And through him, it will be, the state would be moved. So that the Home Department writes to their Home Department to give extended cooperation.
His affidavit is of lawsuit 2012. The affidavit filed by the government here is of 2012.
But definitely, because after that, the court did not take up the matter as in the right earnest. You see, what happens is, every time we are not conscious of what we are dealing with. This may be in a case of missing 2 girls. But if I don't read this, in usual course, it gets adjourned, postponed. And we did not ask the updated report to be placed,
Understand.
and therefore everything is missed.
Such matters have to be.
Out of the 3 persons here, Mr. Pragasta in one side, I am on the other side, you on the other side. If anybody misses a link, then this remains pending issue. You can't help it.
At one point in time, my lord, court was pleased to, my lord, direct the government to produce the updated records. Nothing happened.
What records?
Up-to-date record,
Records are there, case diary, we are sending it back.
and they didn't do anything, my lord.
No, no, what they will do, you see, Mr. Pragasta,
My lord,
you must tell us, you are aware of everything, you are the counsel on record.
my lord.
You should have told us what is the deficiency. The case records are here. I found that these case records are unnecessarily lying here
Case
and it
record
was sent back.
case record was not allowed me to access, my lord.
No, you'll have to make a request to the court. For you see, you are not privy to the to this case diary,
My lord.
but you should point out what is happening. Because you see, unless you pinpoint
My lord.
in a sequential manner, we'll miss out. That's what I'm saying. If there is any communication gap between you, me, and the government advocate,
That's-
this will
that's
happen.
Yes,
I'm
my
not
lord.
blaming anyone, but that is a part of our judicial system. We are bound. We tend to make mistakes
Yes, my lord. Unknowingly, my lord, unknowingly.
unknowingly, because you see, every time I don't have so much of time to read all the files and come.
My lord.
At times we read something, at times we miss something.
My lord.
But when I found this is a girl's case missing, today morning you were not there, I was still taking it up.
Today, yes, ma'am, today, my lord, I was.
Today also, the last occasion also you were not there.
Last occasion, my lord, I was in Arunachal Pradesh.
Whatever be, but then we'll drop a contempt against you. You are in bereavement. That is the information given to us.
No, my lord.
Yes, we have recorded in the order sheet that Mr. A.K. Prakash counsel is in bereavement,
Somebody.
but then we'll drop contempt against you.
I'm sorry, my lord. I don't do the instruction. ma'am. Somebody
We have
must,
recorded, he is in
somebody
bereavement.
might have, my lord. I'm
Well,
sorry.
done.
ma'am.
Okay.
What's-
My lord. I'm sorry, my lord.
Yes, State Bank.
Lordship, they have been cooperating with the investigation ever since, Your Lordship, and whatever they have alleged, Your Lordship, directly against the State Bank has no business to deprive them of anything, Your Lordship. So whatever information was held by the State Bank was already informed to the police.
No, Mr. Manik has made a statement, number one, that in his, in respect of his card, no CVV was issued. You take a plea that your CVV plea is with regard to 17-digit cards, which is not applicable for a 16-digit card, number one.
Take two, please. If subject to correction, I was having a 19-digit card. I misplaced that, given a new card, no CVV as per the RBI. This is first time. Another 16-digit card was also issued to me, which I'd never activated. I filed, it's on record what I'm saying.
And that
Therefore-
is, in respect of those transactions,
Those transactions.
SMS, let's say never sent to his mobile.
Our specific stand was that there was SMS which was sent, but that how that did not reach him was not within the control of the.
No, but the fact that it is sent, it is auto-generated. must be docketed somewhere.
Yes, Lordship. Even on the previous occasion, on one occasion, Your Lordship, somebody from BSNL was summoned, Your Lordship, and he came and deposed that the records for such a old transaction is not with you, Your Lordship. That is the
Correct,
problem. And even I have gone through the records, Your
No,
Lordship.
no, you see, if, let us say that you receive a message that now we have activated those SMS, what you call SMS service. Say from a district court, if your date is fixed on tomorrow in a matter, you get an SMS alert from the civil court, right? It is auto-generated to the system. But once an auto-generated SMS is sent to you, we will have a record. And he has made the complaint at the appropriate time. It's not that he is making a complaint after 10 years. When his money was lost, he went to the, got a statement, he reported to the bank. And you can't say that within that time you lost the track of the SMS alert.
But I can say, Your Lordship, from the police report that has been submitted by the state.
It is a fraud. Somebody in Thane had done it.
Has done it.
He'll be entitled to the money.
And,
then.
and regarding the SMS as well, Your Lordship, there is a specific finding, a specific statement in the police report that his phone was not seized by the police to see whether the messages were properly delivered or not. He did not submit the phone as well. I think it is on record as well. Your Lordship. In that
No, even you never asked it.
Yes, sir.
You see, let us assume that I am not an honest man. When I am sending it, I am giving a complaint, you will presume that I have deleted it and then I have gone to you to make a complaint. Let us assume that worst is worst.
The counterpart should be, the burden should be on the other side.
But you have generated the SMS. Non-receipt is something else, but issuance of SMS itself is a proof that you have done your work. You see, it's just like a presumption of service is made when you have issued it at the correct
Address.
address
With proper postal stamp.
with proper postal stamp, and it doesn't return back within 30 days, then it is presumed to be served. So now if you have sent it to the correct phone number and it has been issued from your end, maybe for the moment my telephone is switched off, I will not get it. Say I'm for 7 days I am indisposed, I am not having my phone. I will not receive it. But then you get back a message that could not be delivered. Usual SMS. If I am sending it, it is not going, it's not pushed. You get back a message that is not going. But if the failure of transmission, you get back. But if the transmission is perfect and still I am not receiving it, that is my fault. I am switched on my phone, I am not getting it. So failure of receipt is two. Number one, mobile is not in an active state. Number two, transmission failure is there. When you get back a mobile SMS saying that
Could not be delivered.
failed.
From their statement, Your Lordship, they are stating that they have been receiving the messages all throughout, but only in case of these transactions, the messages were not delivered to them. That is their allegation. Whether
In the entire thing, we are missing the obvious. Whatever I say, or the bank says, or the police would say, has nothing to do with it. It's called CDR in science, called detailed record. It's nothing, this doctrine, the law on pleadings would not even apply, it's scientific thing. Called detailed record, which is not in my custody. BSNL is there. Bank cannot make that statement. They are doing it with money, they don't deal with science.
most of the time,
The called detailed record has to be there. And I make a positive statement, these were received by me, these were not. The records were under the BSNL, the BSNL is there.
No, I'll tell you. You see, when we are activating our system to give you an SMS alert, it's a computer generated alert. Through a server, it is relayed through a mobile SIM and transmitted. Correct. So call record will be available, number one, for the transmission made by SIM, but the auto-generated SMS will also be recorded in our system,
Right,
where we say that the auto SMS generated.
generated.
Because for that, there's a record in the system that it has been generated, number one.
The footprint is left there.
Yes, footprint has to
So
be saved there.
That's the only way we can see, and therefore, the police, the stand of the police, if I may read, the SPCID is made, they also have it. The victim, Sri Dilip Kumar Goswami, claimed that he did not receive SMS alert while the money from his bank account was fraudulently withdrawn by culprits, which is denied by the banking authority, stating that either the password was compromised or shared. For finding out the actual fact whether SMS was received or not, the mobile handset was required. The former IO did not mention in case diary whether the mobile handset was collected from the Sri Dilip Kumar Goswami or not for downloading text messages. In this regard, it has to be noted that incident of fraudulent transaction occurred in between 8/5/12 to 17/5/12. Neither the inquiry officer, Inspector Munin Zamwa of CID, nor investigation officer of the case, Inspector Ghulam Muhammad of CID, since retired, collected the CDR of the scene noted. As such, there is no scope to verify the truthfulness of the version of Dilip Kumar Goswami to establish whether he received SMS alert or not. It rests here. Since the fault lies with the authority, I'm making a positive stand. They have assuming that I'm lying. It's an assumption that I'm lying without carrying out their lawful duties, which they ought to have done. Now, whether I can be put to blame for an apparent negligence on the part of the authorities, I put that question to myself, my lord. And the answer is invariably no. Right on time, I was active. My grievance was lodged. My sin was blocked. I tried all legal means. All authorities were on, and a culprit was identified. Tomorrow it may happen to me as well. And during this, my credit card also got hacked. I placed an affidavit. In fact, they told me, sir, your credit card is also hacked. So if the system is not so secure, where do I park my money? That's the second question coming. Today I am for 4 lakhs. It may 40 crores, 400 crores. It's the same thing. It may just go. The idea is not to secure this money to that man.
Best is to be in the profession of a lawyer. The bank will never issue a credit card.
So, what do you know, my lord? The larger question which we're addressing by way of this writ petition, at least to the society at large, is that every bank is a custodian of not only the money, but of also our trust. We trust in it. Something happens is different thing. There's a robbery, different thing. But online system was made for the development of the society, and loopholes therein we cannot plug. Coupled with that, if they don't do their duty, the bank or the police whatsoever, I was ready with everything. There's nowhere to go. And they're all allegations, either realm of wishful thinking. It is not supported by document. Whatever I state, I have a document to stand on. I have some action done, taken to rely on. They're not doing that. And in fact, CID is supporting my case. In such a case, whether or not I'm entitled to a refund, I leave it to your lordship. The gentleman has died, his legal heirs are there. Whether or not I'm entitled to a refund is a different issue. But the inaction of the bank authorities from the point go. I say that, my lord, because many years back when I was into the case, I could learn that although these things are automated, the moving on, the OTP, which is generated, it is also within the knowledge of the bank. It is not that it's a random number from a computer sent to me, which no one has any concept, because it has to match. Possibility also lies on the other side, which we are also not addressing at the moment. For the bank to say in detailed affidavit that I was doing it, that may not be correct.
That may be correct.
Even if
You
I
see,
think it
it's
may
a
be
simple
correct.
reason. You see, there is a positive logging entry in our computer system when you log into the High Court website to get a copy. Say you want to look at a case. You are given a captcha. You do it, and therefore, what is entered is weirdly that there is a what you call the IP from which you are logging is identified. Only that much,
Nothing more,
nothing more.
but that
Because
IP
then what happens is that the IP is captured,
that protocol is, that's yes.
and therefore, when some mishap happens, we can identify the
The location.
computer to which this hacking is taking place or something wrong has done.
But for this, with all respect, my lord, this would not apply to the present case. Because the RBI says, and I'm under RTI reply on that, CVV was not there at that time. And without CVV, I cannot carry out any online transaction.
That is for the second card.
Second card was never activated.
Okay.
16GB never, I have placed detailed documents, whatever is where. They're mistaken on the card number and the number of digits. And also on the fact that the requirement of CVV. Page 31 is the clean sheet, that's the sheet anchor of the case. I did not have it. Even if I want to pass on the information to Mr. X to do it from somewhere else, he also cannot do it from anywhere. He did not have it. So the loophole was there in the system. I understand it was in a nascent stage then. It's much advanced at the point now. But these things are going on. Today we have phishing activities. Earlier it was back then different. But online transactions are riskier. We have opened up everything online. When we do GPay transactions, Paytm transactions, they do not take the responsibility for this transaction. It's merely a routing process. On the other side, they give us some rewards and etc. But we are compromising with the bank because we are at the bank account. And that's my self-volition. No one asked me to do that. Google Pay never asked me to, Mr. Bunny, come and do it. I did it for my convenience. If I lose, I lose. But here, when I park the money in the bank, then the responsibility comes. Whether there can be any negligence attributed to me by the record. And the answer is no. It can happen to anyone.
Yeah, Mr.
Lordship, understand something wrong has been happened, your lordship, but whether state bank can be attributed with the liability with the liability for that, your lordship. In the second affidavit, your lordship, there was some mistake with the card numbers in the first affidavit. Thereafter, we have clarified by filing an additional affidavit, your lordship, whereby we have stated that whatever wrongful transactions have been done were done through the first card, 19-digit card. They did not have the CVV code. Under such circumstances, that card which did not have the CVV code was to be used in physical form for availing any transaction, your lordship. So our stand, but whatever assumptions or whatever presumptions we could draw, because we are not the investigating authority to understand what has happened. Whatever transaction has been done, fraudulent transaction has been done with that card, might have been done with a physical copy of the card and the physical ATM pin, your lordship. That is the assumption that the bank has placed in the additional affidavit. And
No,
CID negates that.
because you see, if that be so, then your statement will show that it was done a POS transaction from a ATM.
Lordship.
that's what your lordship. It's using the ATM, your lordship.
No, but where is that statement to show that this transaction?
The contrary statement, the CID statement is there.
And the statements are also there, your lordship.
Show me that this
But-
transaction is a POS
transac-
transaction from an ATM.
The lordship, it is annexed as Annexure A to the second affidavit, your lordship. Affidavit dated 9/5/2019. The very end of the bunch, your lordship.
Yes, 9/5/2019.
Page 8 is Annexure A, your lordship. The
Yes.
Statements, your lordship. It's the statement pertains to all the transactions of that relevant period, your lordship. And most of the transactions, your lordship will find POS ATM purchase. The allegations that they are making, your lordship, are all POS ATM purchases. In paragraph 4, we have clarified it, your lordship. So whatever, I understand whatever stand we have taken, your lordship, is presumptive.
No, then you'd fail
Yes.
for a simple reason. You see, take this. Now we have the advantage of university with the mobile. Now, this is the mechanism which triggers an automated SMS. Correct. In the boxes below, you will find there's an example given of a shop using a SMS alert. Once that is entered, then SMS alert is issued. Last 4 mobile digital numbers, and then the message is automated. So therefore, the system will retain the mobile number in which SMS alert was sent. Has to be, it's a dedicated what you call portal, because a message sent to Mr. Mukherjee will not go to Mr. Hazarika.
But your lordship, as the transactions were of 2012, I'm not sure if this advanced technology was present at that point of time to record the phone numbers. At the
No, it's always there because it's automated. Automated means if you fill up the if parameters are there, then it will be generated. So there must be a system. Otherwise, you see a difficult situation will be in. A message sent to you. You go to Mr. Hazarika, he may not like it. He may find it offensive, which you may find amusing. Same message goes to Mr. Hazarika, he would be offended. And if it goes to Mr. Handik, is just laugh and delete it. So we have to award compensation to the petitioner.
Lordship, two things, your lordship. Once we have tried to show that this transactions were done through POS transactions, your lordship, to the next statement, your lordship. So our contention is that in all the transactions, fraudulent transactions, the card or the ATM pin was used, your lordship. So our presumptive stand is that either the card or the ATM pin or both were compromised by the petitioner. And this presumption, your lordship, is based upon certain things as well, your lordship. Starting from here, we could, during the course of this proceeding, your lordship, where from 2012, we could learn that the card was misplaced and then a fresh card was being issued to him, and then everything came up from police report and everything. But if your lordship comes to page 21, the FIR that they have initially lodged, your lordship, before the police on 18/5/2012, it was sent through fax to the concerned police station, because at that point of time, page number 21 of the writ petition, their own document. It was sent through fax, your lordship, to the concerned police station, because to CID, yes, Guwahati, because at that point of time they were at Koramangala. Here they have specifically stated that at no point of time they have lost the card. And subsequently, during investigation and during everything, it comes up, they have lost the card and a fresh card was issued. So this shifting of stand by the petitioner brings a presumption to the mind of the banker that they might have compromised the ATM pin, or the card which was lost may have been recovered later on, or something may have happened. We are not in a position to investigate and find out everything at our side.
Shows that where is that loss and all. Show me the sequence.
Loss was, lordship will find it in the police report that is submitted by the, I don't have the copy of the affidavit filed by the state, your lordship.
These are matters of record and I stand by that. Therefore, in the
No, let him complete his part.
first step, I opened up that way.
Stated affidavit. It's the affidavit in opposition filed by the state, your lordship. Here's point number 2. That's point number 3. It's the affidavit filed by Pavindra Kumar Nath, APS. I think the IO. Date 13th February 2019. Additional affidavit filed by SPCID.
Yes.
Lordship, at page 5. The third point C. During investigation, it has come to the light that the customer Sri Dilip Kumar Goswami reported before bank authority that earlier card number so and so was found misplaced and he could not recover, for which he prayed for issuing another ATM card in place of the earlier one, for which bank authority issued another ATM card against the account by card number so and so. While replacement of ATM card was done, whether they inquired from the bank whether the phone number was incorporated with the account number so was replaced while replacement of the card was done. And then again in F, it was reportedly known that the customer Sri Dilip Kumar Goswami, holder of the account number so and so, reported your branch about misplace of his ATM card number so and so during 2010.
So these fraudulent transactions were from this, what do you call, 16-digit bank account or
The
17-digit bank,
19 digit. The
19-digit bank
19.
account? The transactions were
2010, misplaced or lost, replaced. Incident occurred in 2012. It's correct for me to say I have not lost or misplaced this card. These are documents with the authorities. While filing a writ petition, we have pleaded everything in detail. The basically obvious, my lord, I could not have carried a transaction.
just a moment. This this 19-digit card was lost.
Initially,
You got a 16-digit card thereafter.
19,
Replacement.
Replacement was another 19 digit.
19
card
digit.
initially.
Another 19.
16 is a separate thing,
Okay.
which they misconstrued, show confusion, which we never activated, accepted it also. 16 digit goes, but 19 digit has no CVV. And what we are trying to on is that, you know, the version of the CID of the same SPCID page number 6, the same affidavit. which
Just
was
let me complete his part. Otherwise, I won't understand. Yes,
The replacement card was another 19 digit card. Your lord.
19-digit card. Okay.
Thereafter, as the system changed, we issued a 16 digit card to him and he did not use it, admittedly, and we say that he did not use it. All these fraudulent transactions were done through this 19 digit card only. the
First card or
previous
second card?
I lost one, I got the second.
No, this transaction is a first or second.
Second.
second card.
Second.
No, let him say.
The second card most probably, because your lordship, the 19
So
digit card
therefore,
number.
whether the first card is lost or not is immaterial. If there's no fraudulent transaction of that, you can't say that this card was compromised, sent to somebody else through which card fraud was done. That argument will fail.
The record available with me shows that there is only one 19 digit card number. So it may happen that the lost card and the fresh issued card were having the same card number, because
Can't be. It can't happen.
the previous card number is not available here.
That
It's a
can't
pleaded
happen.
thing. It's a pleaded thing. I pleaded the card number. And the bank would say they don't have it.
Two
It
separate cards.
can't happen. There can't be a duplicacy of card numbers.
Paragraph 3 of the.
It happened in the second card. Your
Paragraph
lordship.
3 of the.
Second
two
card.
cards.
332, ending with 332.
So therefore, the first card, whether it is lost or not, was not misused for the fraudulent transaction. So that matter ends. So now you have to consider it on the second card.
Second card.
But Mr. Mukherjee,
Lordship.
you think the SPCID says that they went to Thane or whatever place in Maharashtra, they went there. They could identify 2 IPs and 10 could not be identified. Correct? One belongs to one lady. One IP address is of a lady. The name is also given. Now, is it the bank's stand that the IP address through which these transactions were made, 12 IPs, they are all ATM IPs? It's not there. So purchase through ATM could not have been made in the first place. It's a IP generated, investigation is IP centric. Says that there are 12 IPs have been identified. So how does the bank explain that this transaction can be routed through the ATMs? Because even in ATM, when you use an ATM, 2012, I won't know whether I had ATM or not. But now I had.
I recall 2012.
Okay. So this, so in withdrawing from ATM, you have to have an OTP or what you call some sort of what you call this code has to be given.
PIN codes.
PIN code. PIN code is not a 4-digit code, not a CVV of 3-digit.
4-digit code.
4-digit code.
So here, admittedly, there was no involvement of a CVV. It was a 4-digit code and the physical card that we have alleged, Your Lordship. At that point of time, this 19-digit cards did not have the CVV code. It came later on in 2013 or 15 with RBI's guidelines and everything.
Okay.
So the previous card that was used did not have a CVV code.
No, but then the statement of the bank and the police would be in 2 different footing. Your statement says ATM purchase.
POS purchase. That is what.
And the police says that it is an IP based, what you call, a transaction, out of which 2 was traced. They went to the place. They did not go with that bank statement to an ATM call center, or sorry, ATM center, and found out the fraud.
That's what, Your Lordship. Whatever transactional details we had, Your Lordship, we have submitted everything to the bank, to the investigating authorities, Your Lordship. My humble submission here, Your Lordship, is that I don't know whether there was a fraud with him that happened with him or not, because the bank is not in a position to strictly say that he has misplaced or misused his card or he has not done that. Whatever information or input we had as State Bank had provided all the details to the investigating authorities to find out the real facts, Your Lordship. Even the bank will not like anybody or any of its employees or agents to be present in the bank who is doing all these fraudulent activities, Your Lordship. Even bank is strict to that extent, Your Lordship. So playing fraud with the petitioner or trying to hide my employees or hide my negligence on the part of the employees is not the case.
Nobody is saying that. I have not for a moment said that you are a party to it. We are just trying to find out the fraud.
That's what, Your Lordship.
Because if we accept the CID statement, then the transaction was never routed through the ATM. ATM could have been done only when there's a closing of cards or something else.
That will require the closure of the police case, Your Lordship. A final report in the police case or the charge sheet or whatever, in whatever form it comes, Your Lordship.
No, we
That will
can't.
be required, Your
No. Because the court order is not subservient to the police
I
investigation.
understand, Your Lordship, but when an investigating authority is carrying out its investigation, it should come out with some specific finding to attribute
They
the
have
fault
to.
to somebody. If there are inconsistencies in the records with the State Bank, Your Lordship, and the records with the investigating authority, it has to be found out, Your Lordship. The correctness of which one is there. Because the investigating authorities are well capable to find out if the fault is lying with the bank or if the fault is lying with somebody else. Maybe
Well, once we have not
after
addressed
10 or
against the bank.
11 years, the authorities may not catch hold of the accused, Your Lordship, but at least the fault may be settled, Your Lordship.
We are not fault finding with the bank. It is not a petitioner's case, we are fault finding with the bank. We say there was a breach of the system. The system breach needs to be addressed. And since the bank is the custodian of that, they have to compensate without any fault on their part, if I may say so.
Okay, I have dated also to the next date.
Okay.
Let me have an input of this, what you call ATM transaction. This is something I don't know. I'll go to the university and find out.
But it has to go back of that time. Presently, it is much more developed. Earlier, it was different.
The old university vice chancellor is no longer there. When I go to a university today, I'll be obviously updating myself on what is happening today.
In this case, my lord, regardless of anyone's stand, the small campus where we are placed in is that IP addresses have been detected by a competent authority having jurisdiction. No one is challenging that or doubting that. Money is gone. No one is even doubting that or saying no, it is not gone. Persons are being identified but could not be caught. The matter rests there. In such circumstances, when the card which was held, admittedly, everyone's case is that it did not have the CVV, could not have been done, and internet purchases were made. The system being new.
No, not
Because
as
can
not,
be-
now Mr. Mukherjee is showing that the transactions are ATM based.
Even I have annexed those documents. It is not an afterthought. Even I have annexed those documents to say that these are mine, rest are not mine. These are not mine. They are not disputing the fact that the card could not have been used other way around. What they are saying, I did all these things, which is directly in conflict with what the CID has come up with. Now, as long as the stand of the CID is there on record, it supports a case of online fraud. The system has been hacked, if I may put it that way. I'm not against the banking officials, but their upfront denial to come to my aid shows that there is something more than what meets the eye. We all have faults, we may accept it and move on. 2012 system was not so up to the mark. Things happened.
It may happen.
Maybe then they first. Pretty close to the boundary.
There is.
I'm able to get it.
Not yet.
Detailed orders on Tuesday next.
There's another possibility that I'm not a technical expert, but I'm just saying, Your Lordship, the transactions, so POS ATM purchase, Your Lordship. POS, as per my understanding, is a point of sales machine, Your Lordship. If it is connected to a computer, whether the IP address of that computer will be shown in the POS purchases or not.
Fake
is a question,
addresses.
Your Lordship.
That's what came out, fake addresses.
I'm just thinking it's, maybe that's another aspect of the matter, possibilities.
No, but you have to inform me, this is a technical thing, I don't know.
After the.
POS in ATM card, when my statement comes, it shows POS transaction.
Yes.
ATM also shows POS transaction.
If it is swapped in some shopping mall or somewhere, Your Lordship, it will be a POS transaction because
What
they are
happens
using
is
that point of
there's a-
sales.
Small machine if Lordship come across, but debit cards are either punched or swiped. It becomes a POS, ATM purchase, because the debit card is physically used. Once the debit card is swiped or punched across a machine, suppose Reliance, I go to Reliance, or the other case, Louis Philippe, I go there and I opt to pay by, not by Google Pay, but by swiping my card. POS is there, but it becomes, so far as the card is concerned, it is there. But I wonder 2012, those were not there. These things were not there. At that point of time, transactions where I had to feed in the number. I had to feed in my 19-digit number or 16, whatever the case may be, along with the month, date, expiry, etc. And then the OTP comes. Back then, it was that way.
Even expiry date was also not there. In 2012, even the expiry date of the card was also not there. The ATM pin had to be fed with the number. 4-digit ATM pin.
IVR came much later. Interactive voice response came much later. Where assisted, where the credit cards or the banks would have an IVR. We call up and they assist us across. Even for those things also, the SMS is mandatory to give the SMS, even for IVRs. Okay. But we are confronted with the situation where the CID is supporting it, the fraud. Only the helplessness is that it could not be nabbed. Be there in the second half of Tuesday. Dictation over. Obliged. Just what the names, Mr. As many counsel for the petitioner. Mr. G. Andy Clanet. Standing counsel for respond number 1 and 2. Mr. P. Hazarika Ranel. Counsel for respond number 3. And Mr. B. J. Mukherjee and counsel for respond number
4 and 5.
4 and 5.
And Lordship 7.
Achha, you are for 1 and 7. Okay.
1, 2 and 7.
1,
2 and
2 and 7. Okay.
6 is BSNL.
6 is BSNL.
6 is BSNL.
Was represented earlier. 6.
You can record whose name is CKS Barwa was here. CEC Mr. CKS Barwa was here. CKS Barwa is also a CGC.
Yes.
Okay. CKS Barwa CGC for respond number
BSNL is 6.
6. Nine.
The case also has faced, the judgment has faced.
Which one?
Pallab Bhumi.
Ah, yes.
Perceived negligence. How the bank's liability come in. Paragraph 25.
That's okay. Judgment for Pallab Bhumik. Ah, it is there.